So much has been spoken about judicial appointments in this country, and especially the dissent of Justice Nagarathna and the recent Collegium decision. Your thoughts on it?
So I personally feel that either the whole of the collegium deliberation should be put in the public domain, or if it is not to be done, then simply putting a dissent will really not serve much of a purpose. Recently, I heard Justice Oak in one of his interviews, mentioning that when they discuss a particular name, a lot of people say a lot of things which may not be palatable or which may actually amount to invasion of privacy of that particular individual whose name is being considered. Now, if you consider, because there are aspects which are not something which are borne out from any record, like for instance, person of doubtful integrity. Now, doubtful integrity is more of hearsay than a documented or a paper-based finding about a particular judge. But if the judges in the collegium know that this person who's aspiring to be a judge is a person lacking in integrity, by virtue of even hearsay, I think that also is a good ground for them to not consider him for the purpose of elevation. Now, if you start disclosing that this person is of doubtful integrity to the public, just imagine the damage that you will cause to that person's reputation without giving him an opportunity to respond. And also, many a times, people's income tax returns are being discussed. So even those are very private details of every individual which can't be disclosed to the public. So according to me, either the whole of the collegium deliberation should be made public or not at all. As far as the dissent is concerned, in my view, if Justice Nagarathna had only asked for a woman judge to be elevated to the Supreme Court and objected on that basis, rather than hair splitting the recommendation, although I'm sure she must be having very good grounds to make whatever objections she had, but not asking for a woman judge to be elevated in those two vacancies, according to me, and being a woman herself, I think that was a very important, should have been a rather very important aspect of any objection to the deliberation for elevating a person to the Supreme Court. Because as of now, there is only one lady judge in the Supreme Court, which is below 3% of the strength of the Supreme Court. And to not have in the national average, if we look at the lower judiciary, the percentage of women where appointment is purely by merit is almost 40%. So to have only 3%, less than 3% in Supreme Court is something which is, not at all acceptable. And I feel that the collegium decision making should have, in my view, a criteria for what they will appoint. Rather than what they are actually doing, they decide to appoint a particular person, so they say he'll be a Chief Justice of India, so we are appointing him. You want to appoint somebody because he's a backward class, you say he's a backward class or a scheduled caste or a lady, or a person from a particular state where there is no representation. Whenever an appointment to the Supreme Court takes place, according to me, there should be at least 8 or 10 issues which should always be discussed. State representation should be one, regional representation should be the other, gender representation should be one, merit should be the most important. According to me, appointment to the Supreme Court should be only merit based. And because ultimately Supreme Court is laying the law of the land for the country, and anybody getting appointed only on one of these considerations will definitely not be in the interest of this institution. So even when you appoint somebody, either a woman or a backward class or a scheduled caste or a regional representation, merit should never be a casualty. So according to me, if you look at all the names which could be considered for elevation, and when you look at names for elevation, you should always, alongside, every time, have sufficient number of names from the bar also to consider for elevation, so that you have the choice of going for a very wide spectrum of options available to you. By that process, you will be having merit as a prime sort of consideration for appointment to the Supreme Court, and then the regional representation, the gender representation, etc., should be also factored in. So the appointment ultimately, or the recommendation appointment ultimately should be a holistic point, considering all these points of regional representation, gender equality, backward classes, whatever you feel are important for the purposes of appointment to the Supreme Court. That will be the only way you can ensure that the right people only get selected for the Supreme Court, and there is no favoritism or there is no partisanship in making such appointments.
Just a follow-up point. You've spoken on many occasions about the Memorandum of Procedure. I know we have one, but if we had something which is more elaborate, more descriptive, would it have smoothened the process?
So, a very interesting question, because today itself I have written a letter to the Law Minister and to the 5 judges in the Collegium, asking them to frame the Memorandum of Procedure. We don't have a Memorandum of Procedure after the NJAC judgment. The NJAC judgment had, for the first time, prescribed what should be part of the Memorandum of Procedure. And thereafter, there has been no consensus, because the NJAC judgment had a very, I don't know why this was done, but it had said that 5 judges, 5 senior most judges of the Supreme Court should without exception or without any dissent, agree for the framing of the Memorandum of Procedure. And probably because of that reason, till today, a Memorandum of Procedure has not been able to be formulated with the Law Ministry. And exactly what I have written today, that there should be a Memorandum of Procedure which should have, which itself will bring in transparency in the appointment process. I have talked of, providing for an eligibility for different high courts. I have talked of, providing for a data bank for the Collegium to consider, secretariat for the Collegium to know what are the names in that particular eligibility criteria who can be considered for elevation. I have also said that ultimately, why not ask applications? If you can take applications for senior designation, then why not applications for appointment to the higher judiciary as well, especially to the high courts? Because I have also pointed out in that letter that a wide spectrum of very, very talented lawyers who are doing the briefing work, who are the junior lawyers who do the drafting work, are not being considered for elevation at all, because the face which is there before the judges is the arguing face. But many a times the arguing face may only be doing what exactly has been told to him by his briefing counsel. And the briefing counsel remains completely faceless in this whole exercise. And probably the arguing counsel, if he is a young arguing counsel, he would be more suited to become a well-known senior advocate rather than becoming a judge, and that is why most of these people refuse to become judges. Whereas if a briefing counsel who has been doing good drafting work, good analytical, legal analysis, and also deciding the brief for the client, what exactly, how to get relief for the client, I think he is the best suited to be elevated as a judge. So he can't be considered in this present system at all under any circumstances. He or she can only be considered if there is a method of applying where somebody interacts with him, finds out from his particular senior or the seniors whom he or she has been briefing, so that to find out about his capability, his or her capability. And that is the only way you can get to the right people in the system, because ultimately I have seen a good judge decides all the matters which are before him, and a bad judge just sits over 10% of the matters and adjourns all the 90% of the matters. So we need judges who would be able to decide all the matters which come up before them. And I've seen there are a lot many judges who do that on a daily basis. Even in various high courts I've seen. But the judges who are not good in first principles, they just keep on and on with on matters, and they just don't decide matters. So I think the merit in the appointment process is actually taking a big beating in this process, and that can only be done by a revised Memorandum of Procedure with the present Collegium and the Law Ministry.